All right, so welcome everyone to this webinar on Hassan Diab, Justice Denied. Please note that this webinar is being recorded and a recording will be available later on. The chat has been disabled, so please just use the Q&A function. As also, the raise hand function is disabled. We want to thank Independent Jewish Voices of Canada for offering us this opportunity to conduct the webinar, and a special thanks to our webinar host, Tamara Filyevich. We are very grateful for the continued support. So, we decided to hold this webinar to mark the 6th anniversary of Dr. Hassan Diab's unconditional release from a French prison in January of 2018. We also want to bring you up to date on Hassan's case, since a lot has happened in the last 6 years. I'd like to introduce each of the speakers in the order in which they will appear. And so our distinguished panel includes members of the Hassan Diab Support Committee and other intrepid supporters. In order of appearance, they are Dr. Hassan Diab. He is the person who, along with his family, has been forced to endure more than 15 years of a Kafkaesque legal odyssey. Today, he will try to briefly summarize that history and apprise us of the current situation. Hassan is a Canadian citizen and a sociology professor who lives in Ottawa. As you may know, he is falsely accused of planting a bomb outside a Paris synagogue way back in 1980. Following his arrest in Canada in 2008 and his extradition to France in 2014, he spent over 3 years in a French prison. Dr. Diab was fully exonerated and returned unconditionally to Canada in, as I said, January 2018, after 2 highly experienced French investigative judges determined that there was no evidence linking Hassan to the bombing. Since then, however, French prosecutors, under political pressure from French interest groups and the victims' lobby, appealed his case, and despite a wealth of evidence exonerating Hassan, he was declared guilty by the Special Court of Assize in Paris in April of last year. Hassan now lives in a seemingly endless state of limbo, not knowing if or when the RCMP may come knocking, and if he might be extradited a second time to France for a crime he did not commit. I will be your next speaker, Don Pratt. I am a founding member of the Hassan Diab Support Committee and unofficial chair of the Support Committee's regular meetings. I have known Hassan since our days together at graduate school in Syracuse, New York in the late 1980s. I will share some impressions of the trial that I attended at the Special Court of Assize last year. Next will be Roger Clark. He is the former Secretary General of the Canadian section of Amnesty International. An indefatigable member of the Support Committee, Roger will address the human rights implications of Hassan's case. Then we'll have Michelle Weinroth, who is a steadfast and eloquent supporter of Hassan Diab, who has advocated tirelessly on his behalf. She joined our efforts in 2016, and her talk today is entitled "The Hassan Diab Affair and the Politics of Deceit." I also want to give a nod to our Q&A moderator, Bob Thompson, who is a longtime member of the Support Committee. All right, in a moment, I will ask Hassan to take the floor, but let me just say a few more things. We welcome your questions today. You may pose questions by typing them in the Q&A window at any time during the session. We will get to as many questions as time allows. When posing a question, You can specify that you wish to direct it towards a particular presenter, or you can leave it open for any presenter to address. We will also reserve some time at the end for you to offer strategy suggestions to the support committee. We will take these suggestions up at a subsequent meeting of the support committee. Now, on to our presenters. Each speaker will be under a time limit for their remarks, so please understand there is more we could say if time allowed. And of course, the Q&A may provide an opportunity to touch on some of those things as well. I will now give the floor to Dr. Hassan Diab.
Okay. Hi, everyone. Thank you for coming today to this meeting. It's my pleasure to be with every one of you. I will give just an overview of my case, which started more than 15 years ago. I would say more than 16 years ago, in October 2007. A French Le Figaro journalist, Jean Chichizola, his name was, came to the class I was teaching at Ottawa University and told me that I'm suspected of involvement in a bombing near a synagogue on Rue Copernic in Paris in 1980. Of course, I rejected and denied this awful allegation. I believed it was a case of mistaken identity. Hassan Diab is a very common name, is more than Michael Smith, maybe Smith here. The last prime minister of Lebanon, his name was Hassan Diab too. Following this interview with this French journalist who told me a few things, that interview, I would say, marked the end of my life as I knew it. Everything changed, but I didn't notice it because there was some 13 months of surveillance. I didn't know who was following me, and I did not notice at the beginning. When I noticed a few cars, intrusive drivers and people around me, I called the Ottawa police and they filed a report or whatever. And then I called, even at least in 2 occasions, 911 at no avail. And that was that. The surveillance and followed me for lasted for 13 months until November 2008, November 13th, when I was arrested by the RCMP and was sent to the Ottawa Carleton Detention Center, Ottawa OCDC, which is, I call it, the worst place in Canada. And the media coverage was totally negative all that time, filled with character assassination and with no space for any benefit of the doubt. 4 and close to 5 months later, I was released on bail. That was April 1st, 2009. And after spending all this time at this horrible place, OCDC, the bail, I had these I was released on bail under draconian bail conditions. I had to pay close to $2,000 per month to finance my own anklet or the ankle bracelet. I had to find some sureties, people who would be my sureties. We found 5 people who it was nice of them, to put $335,000, I remember. I could not leave my home without a surety, and at night I couldn't leave my home at all from 9 p.m. to 7 a.m. And right away, the extradition hearing started after I left the OCDC in 2009, and lasted the extradition hearing until 2011, a little bit over 2 years. And but the hearing was based on the record of the case. There's something called record of the case. The requesting state here, France, submitted to Canada, and I couldn't argue or deal with anything outside the record of the case. Even I couldn't say, like, I was in this particular meeting today when something happened, I don't know, in somewhere else in the world. I had to do this only in France, and I can only deal with elements in the record of the case, nothing else. Even if I had all the alibis, everything doesn't matter. This is due to the shortcomings of the Canadian extradition law. The record of the case, we discovered that it was full of unfounded allegations, contradictions, wrong information. Even it's not just our opinion or the defense opinion, it was even the Canadian extradition judge's opinion to a great extent. According to this record of the case, or they call it ROC, 5 Palestinians are suspected of carrying out the attack in 1980. That journalist, the French journalist, Chichizola, insisted when he met me that I was Palestinian. When I told him I wasn't, he passed that information onto the French investigators, who tried to fix it and to correct it in the record of the case, but they didn't know how to fix it well. They kept it 5 Palestinians. One of them is the Lebanese, Hassan Diab. You know, they forgot to delete the first sentence. The second point in the record of the case, I would say, there were contradictory eyewitnesses or witness statements regarding age, build, hair color, French language abilities, and so on. They all contradicted each other. And the record of the case is based mainly on secret unsourced intelligence, whose origin is unknown, even unknown to the French authorities, and which may have been the product of torture. Later, that intelligence was removed from the record of the case. France removed it because the reliance on intelligence is unconstitutional in Canada and is not allowed in a Canadian court. The third point, or fourth point, handwriting analysts, they call them in France, graphologists. If you Google this term, graphologist, you notice there's no difference between graphologist and a palm reader. That's the French way of doing handwriting analysis. They can check or try to figure out your personality through your handwriting, not handwriting analysis in the Anglo-Saxon sense that we know here. These graphologists, 2 graphologists in France, insisted that my handwriting matches the 5 block letter words on the hotel registration card from 1980 that were written by the suspect. Despite this discovery that some samples that they relied on did not belong to me, but belonged to my ex-wife. They didn't know that they belonged to my ex-wife. They mixed them and they got her as maybe the suspect. The last point here about the record of the case, there was right away when the French realized that they were comparing the wrong person's handwriting with the suspects, they dropped those 2 reports and submitted a new report. Unfortunately, the Canadian extradition law allows the requesting state to submit as many what's called files or reports as possible. This second handwriting report, we called it the Bizotti report, Anne Bizotti, her name, was submitted to Canada, and despite the fact that it was criticized and totally rejected by 5 renowned international handwriting experts, the handwriting analysis in my case reminds us, the judge had to rely on it. And this is reminiscent of I'm not sure how many people of you are familiar with the Dreyfus affairs, which started in the late 19th century, around 1890s. Dreyfus, Captain Dreyfus in the French army was a Jew who was obviously, the first accused in passing information to the Germans, and he was accused despite the fact that his handwriting did not match that of the suspect, but the French concluded that he changed his handwriting. They said the same thing in my case. Now we go back right away, 2 years late, in close to 2 years, the Canadian extradition judge, Robert Méranger, decided to commit me to extradition. In his decision, he wrote that France had presented, I quote, a weak case, and the prospects of conviction in the context of a fair trial seem unlikely. But he stated that Canada's extradition law gave him no choice but to commit me to extradition. This judge based his extradition decision solely on the totally flawed handwriting analysis, or the graphologist analysis, Bizotti report. The problem is that in extradition, the record of the case presented by the requesting state is presumed reliable. And this is the dilemma here, or the problem with this rock, because whatever the requesting state says, we presume that it's reliable. So we don't argue with this, no matter how ridiculous and wrong it is. That took, I was committed. We appealed the decision on April 2012. Justice Minister, because we could write to the Minister of Justice at the time, Rob Nicholson, Robert stamped the extradition decision and signed an order surrendering me to France. He assured my lawyer, Don Bain, that I will be extradited to face trial, not to languish in a foreign, like French prison in this case, for years while the investigation continues. The exact opposite happened. I languished for 38 months in foreign prison, and the trial wasn't ready. And at the end, I wasn't even sent to trial. In May 15, 2014, now after we lost almost like all appeals, I lost my appeal at the extradition decision, and a few months later, on November 13, 2014, the Supreme Court of Canada refused to hear my case. Right away, I was extradited to France before dawn. I was whisked away from jail, from OCDC, without having a chance to say goodbye to my pregnant wife at the time and 2-year-old daughter during actually, it was her birthday that day. And I would go now to France to spend 38 months between 2014 and 2018. And there was no trial waiting for me or anything like that. I had to spend all this time in a near solitary confinement, close to 22 hours per day in my cell, while the investigation continued. In 22 hours alone per day, you start talking to yourself. I don't know what I was saying. Now, as a result of this, in 3 years, luckily, they changed the judge and they appointed 2 newly, professional, experienced investigative judges. These are 2 of the top 10 in France, Jean-Marc Herbeau and Richard Folzer, as they call them, took over the case. They did a very thorough investigation that included interviewing me at length and interviewing a large number of people, as well as traveling to Lebanon to collect facts. The Lebanese University in Beirut, where I was a student at that time in 1980, provided the magistrates with documents showing that I was taking university exams at the time of the bombing, which this totally contradicts the allegations of that I was in Paris at the time. Several people, including classmates of mine, were interviewed, and they all confirmed that I was in Beirut at the time. One of them was actually studying at that, not studying, living in the US when they interviewed her last 5-6 years ago. Two students confirmed that I was studying with them for the exams. Now, coming to more important things, my fingerprints and palm prints were compared. Believe it or not, usually, when you have something like this, you compare them once, twice with the suspect's fingerprints. In my case, they compared them 10 times. Exactly. 10 times they compared my fingerprints with that of the suspect. Well, I didn't know how to make out of this. I asked the judges there. They said, oh, wait, we just to reconfirm, but they've never done this before, as I was told by so many lawyers. All results were negative and no match. My fingerprints and palm prints were compared, I said, 10 times. The fact that my fingerprints do not match was actually known for a long time, even before my extradition. And I discovered this when I went to France. The French provided me with the so-called dossier, or a file of the case. They put everything in it, and they did not submit this dossier to the Canadian authorities here, but I had the right to look at it. And I discovered that it was maybe 11 months before my arrest, they did a comparison. They took fingerprints from my immigration file in the US and compared them with the suspects. But they never told us anything about it. They never told the Canadian court about it. And on the contrary, they said something that there were no exploitable fingerprints on the hotel card or on the police document, that the suspect signed a police document at the time. Of course, they found an silly excuse later on. They said, in those days, we did not allow suspects to touch papers that they signed their names on it. You can imagine what kind of an excuse. In January 12, 2018, which is close to 6 years ago, 6 years and 2 weeks, the two French magistrates who thoroughly investigated the case found no evidence to justify even sending me to trial. They dropped all the charges, they call it non-lieu, or dropping the charges, and ordered my immediate release. I returned to Ottawa then, and 2 days later, on January 14th, I was reunited with my family. It was a long journey, 3 years and 2 months just in the French jail, and several years here before, like 6 years or so, fighting extradition. Upon my return to Canada, the media reaction was the opposite of when I was arrested. It was here now, more positive and supportive. It's very contrary to what happened in 2008. On June 20th, it took 6 months, Prime Minister Justin Trudeau to declare publicly that what happened to me shouldn't have happened, and he promised to make sure that it never happens again. This is June 2018, 6 years ago, or a little bit, 5.5. However, this did not stop the French prosecutor from appealing my release decision and pushing for a trial for political reasons, with no new evidence whatsoever. They didn't have any new evidence to rely on. They had the old evidence, and the handwriting analysis was still there. And here now the irony. And I was put on trial in absentia. Can you imagine? It doesn't happen here. You have to be there. A sham trial, I call it, in absentia, took place at the special, it's not just Court of Assize, the Assize, or Special Court of Assize in Paris, where I was declared guilty. At this sham trial, no new evidence whatsoever was presented. The court ignored all exculpatory evidence, including the university papers, the university documents, students who were with me in the exams, all the alibi, all the fingerprints. They just ignored them. And even they, at one point, if I remember correctly from my lawyers, they said uh, they think the university is wrong and the students were wrong. They just ignored everything and relied on something they manufactured.
Hassan, can
Yeah.
you speak more clearly in the microphone, please?
Oh, I'm sorry.
Losing you there a bit.
Okay, I'm trying to. I will be closer. The
Still not
third
hearing
point
you
that
well. Oh,
journalists
that's
who,
better. That's good.
yeah, I said no new evidence was presented in this sham trial. The court ignored all exculpatory evidence, which
Still,
anything that helps us. There were journalists who were invited. They were not witnesses at all after the bombing. And they were called to provide evidence. The court relied on absurd, ridiculous testimony that claimed that I swam from, my goodness, uh, listen to this. I swam from Lebanon to Belgium, or I swam from Cyprus to Greece. So this is how they located me in different countries, because I was able to swim close to 7,000 kilometers. The other point is the court relied on the secret anonymous intelligence, which was withdrawn from the Canadian extradition hearing to decide to declare me guilty. Interestingly, the court did not rely on the handwriting analysis after it was totally discredited during the trial. So now I was sent based on the handwriting analysis. In France, they don't care about it, and they wrote the secret intelligence. That's what I call it significant that the two investigative magistrates.
excuse me, Hassan.
Yeah, can you hear me?
Maybe your microphone has got a loose connection.
No, I don't have a microphone. I speak to the thing directly.
Okay, well,
Can you hear me?
it sort of cuts in and out, mostly out.
Oh my goodness. Okay, I'll try to.
That's good.
Is that now good?
Yeah, maybe don't move around so much. I think that's
Yeah, I
part of the
was
problem.
talking about the two French judges, investigates or whatever magistrates who investigated the case came to the trial, and they just came to reaffirm their position that there was no base for sending me to trial. The bizarre situation now is that in Canada, the secret uh, anonymous intelligence, here we call it, was withdrawn from the extradition hearing, and I was extradited based on flawed handwriting analysis in France. They dropped the handwriting analysis and they introduced the secret intelligence back after they dropped them here in Canada. It's kind of crazy situation. The other point, in France, the Court of Assize dropped the handwriting analysis, I said, and relied on these secret uh, intelligence to declare me guilty. The decision by the Court of Assize cannot be appealed. This is one thing. And it's important to note that there's no record of exactly what happened, no transcripts, nothing in the trial. There's no transcript, I said, no audio and no video that is available to me or to my lawyers. I was informed later on that there's an audio, and when we asked for it, the lawyers in France asked for the audio, the French said, no, it will become available later on. How later? They said 50 years from now, which is 2073. I hope you will be all around to look at the audio. Now come to the last point, which is the limbo situation, I call it. Now, my current situation after the Court of Assize declared me guilty of a crime I did not commit is having a huge toll on me and on my family. My family lives in fear that any day I may be taken away and disappear from their lives. They might even arrest me now before I finish this last few paragraphs. And that's why I say Canada must end this unfair limbo situation, and Prime Minister Trudeau must honor his words in 2018 that what happened to me shouldn't have happened and should never happen again. And now the question arises, what if the Conservatives are in power? Next year, we know there's election, and there's a big chance that the Conservatives would come back. Would they make sure that what happened to me will never happen again, or they will just ignore that thing? Also, the Canadian government must, we must all ask for this. Canadian government must fix this unfair extradition law, which does not offer protections to the accused. This extradition law is unbalanced since France does not extradite its citizens. There's no reciprocity here. France would not extradite French priest, for instance, Johann Rivoire, if you remember 2-3 years ago, who was accused of sexually assaulting indigenous children in Nunavut. The Canadian government must treat all Canadians equally. No one is more equal than others, as George Orwell would say the opposite, maybe. Perhaps my situation will be different, I say, would be totally different if my name was Michael. Then we would be 3 Michaels instead of 2. Finally, what keeps me going now, that's the last one, is this wonderful community of support. People who really have stood by me in the most difficult times and supported me over these 16 years. And my hope and belief that justice will prevail in the end. Remember, this is a case about, I would always call it, when judicial collides with the political, then at the end we know that's what happens, what's happening to me. Thank you for listening. I hope I didn't take too much time, and I hope the thing was clear. Thank you.
Okay, thank you, Hassan. Okay, our next speaker is yours truly, Don Pratt. I do want to talk specifically about the Special Court of Assize in Paris, which I attended in April of last year. As Hassan noted, it's a special court, and that essentially is that it deals with terrorism cases. So the rules are different there. As was already noted, the trial came in the wake of an appeal by the French prosecutor, which overturned Hassan's 2018 exoneration. In France, by the way, overturning a decision by the highly respected anti-terrorism section is unheard of. I have to say the declaration by the Special Court of Assize that Hassan is guilty was essentially nonsensical for reasons that Hassan was articulating, and I will repeat some of those points, especially if you had trouble hearing his audio. It is worth noting also that Hassan's case was the primary inspiration for a Canadian parliamentary committee, the Standing Committee on Justice and Human Rights, to issue a report last year calling for extensive reforms to Canada's extradition law. So here is sort of a list of some of the ways in which the trial that took place in Paris last year was unfair. So the trial was conducted in absentia. Canada does not permit in absentia trials and therefore should not accept the results of such a trial in France. A trial in absentia also means that Hassan is afforded no appeal in France. Secondly, there is no documentary record of the trial proceedings. There is no transcript, no recording. This means there is no accurate record of what happened in the court that could be used by Hassan's defense at an extradition hearing or at any other subsequent proceeding. Thirdly, all the forensic evidence, multiple fingerprint and a palm print exclude Hassan. There is no forensic evidence to support a finding of guilt. Indeed, as I think you may have heard Hassan say, the court simply invented theories out of thin air to explain away the lack of forensic evidence. For example, they claimed someone who signed a statement in, a police station was not allowed to touch the paper they were signing. Never heard such a thing. Fourthly, the court ignored all alibi evidence showing that Hassan was in Lebanon taking his university exams at the time of the attack, despite the fact that there were university documents and eyewitness testimonies confirming this. Fifth, French journalists who were not witnesses to any of the relevant events were called to give their so-called expert opinions of guilt at the trial. Some of these journalists, like the one who visited Hassan in his classroom way back in 2007, are known to work hand in glove with the French intelligence services. Number six, the court relied heavily on unsourced, anonymous, and contradictory intelligence that may be the product of torture. This is fundamentally unfair and is inadmissible in Canada. Seventh, some witnesses who made ridiculous statements, such as that Hassan swam from Cyprus to Greece, had their testimony accepted at face value. Eight, the prosecution attributed additional superhuman powers to Hassan, claiming that he studied for his exams in Beirut, flew to Paris to plant a bomb, and then flew back to Beirut just in time to take and pass his exams. There is absolutely no evidence for this scenario, which also contradicts the prosecution's claims working theory, which assumes that the bomber spent weeks in Europe preparing the attack. In other words, they can't keep their story internally consistent. Number nine, it is important to note that the two investigative judges who spent years investigating the case actually testified at the trial and held firm to their decision to exonerate Hassan. Nevertheless, the court ignored the testimony of these experienced judges. Lastly, the judges of the Special Court of Assize relied on a bizarre feature of the French criminal law known as intime conviction, whereby a judge can rely on their deep personal belief to render a verdict, even in the absence of supporting evidence. And that summarizes my remarks, which essentially show that the court was a sham trial that wrongfully declared Hassan guilty. Having concluded my remarks, I will now give the floor to Roger Clark.
Hi, everyone, and thanks for listening to us. I think any of you who have heard Hassan's comments and Don's analysis of what happened at the trial last April cannot but be shocked by the failure of protection of his rights. It cries out about injustice, unfair process, and miscarriage of justice. What I'd like to do in the few minutes that I have is to talk a little bit about the more formal side of human rights and the denial of rights in Hassan's case. The reality of human rights, of course, is not something that we're just lucky to have. It's not something that we have to go looking for. Human rights belong to each one of us, and they are inherent to our human identity. They're not arbitrarily defined or determined by who or what we are. And denial of human rights is the denial of fundamental human dignity and is itself a crime against humanity, against our humanity and against Hassan's. Denial of one person's human rights is a denial of everyone's rights, and a failure to protect those rights makes us complicit in their denial. So going back to the standards that we apply, and these are certainly important. They came about for every good reason. But I'd like to take us to two documents, two standards that have been set over the years. You're probably familiar with them, so I won't belabor this. But the first is the Universal Declaration of Human Rights, going back to 1948, and was described at the time as a response to the, quote, barbarous acts which outraged the conscience of mankind. And the Universal Declaration has many articles, 30, but I'd like to just touch very quickly on a number of, 6 of those, in fact. One, the right to freedom from torture or degrading treatment or punishment. Hassan was held in his cell for up to 22 hours a day. Essentially, he was held in solitary confinement during the 3 years and 2 months that he was held in the French prison. Courts across Canada have ruled that extensive solitary confinement is, in essence, a form of torture. It is certainly a degrading way of treating an individual. Another article, Article 8, describes the right to a remedy by competent tribunal. I'll just refer you back to Don's description, excellent description of how the trial last April was not only incompetent, but it was totally fabricated, unfair. Hassan, I think, called it a kangaroo court. But in any case, a sham of judicial proceeding. Another article, freedom from arbitrary arrest, detention, or exile. And I'll just leave that one with you. But it's clear that what happened in Hassan's case challenges that right that was established in 1948. The right to a fair and public hearing. Nothing more to say on that one, but it's so evident. The right to be considered innocent until proven guilty. The outrage across Canada in the very early days, which resulted in Hassan losing his teaching post at, in fact, Carleton University. He was teaching in both Carleton and Ottawa U. But the venom and the anger and the attacks were certainly not evidence of him being considered innocent in the court of public opinion. And the right to free movement in and out of the country. Well, I think we can talk at length about the failure of Canada's Extradition Act. You've seen a number of references to that already. Thankfully, there has been some work done by parliamentary committees to reform Canada's Extradition Act, but that has a long way to go before the reality sets in. The other standard that I'd like to just comment on briefly is the Charter of Rights and Freedoms, the Canadian Charter of Rights and Freedoms. The Canadian Charter, in fact, is described as the highest law of the land. In other words, the provisions of the Canadian Charter of Rights and Freedoms is not some sort of fanciful or pleasant document that sits waiting for realization. It is the highest law of the land. And as with the Universal Declaration of Human Rights, we are faced with clear evidence, clear, unquestionable indication of the way Hassan's rights have been denied him. Everyone has the right not to be arbitrarily detained or imprisoned. Everyone has the right on arrest or detention to be informed promptly of the reasons therefor. That did not happen. In fact, it never happened until the trial took place in April of last year. Any person charged with an offence has the right to be informed without unreasonable delay of the specific offence. In Hassan's case, of course, that information took years to come out, and even then was based on wrong information or intelligence gathered from goodness knows where, but certainly was not given the information that is required by the Canadian Charter. Also, any person charged with an offence has to be informed, has to be tried within a reasonable time. Once again, to hold somebody in France, even though France had said that the evidence was already for a trial, it took them 3 years and 2 months to try to put together a case, and that case failed. The same, any person charged with an offence has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. And finally, everyone has the right not to be subjected to any cruel or unusual treatment or punishment. So, and that's only part of it. There's also fundamental moral and ethical standards that we expect in the way we treat our fellow human beings. The right to be treated decently, the right to not be placed in a state of limbo, expecting the possibility of arrest at any moment, the right to be supported by our government when, in fact, the evidence presented fails or is shown to be completely bogus. I'll leave that there, and I think I say little more. It's, as I say, it cries out as a lesson in the denial of human rights. And Hassan, unfortunately, is the victim of that. So thank you very much.
Thank you, Roger Clark. Our last speaker is Michelle Weinroth. I will give Michelle the floor at this time.
Thank you. So this is the title of my contribution, and you will hear some repetition of some of the things that was said in the previous presentations, but that's the peril of coming in last. Quand la réalité dépasse la fiction is the expression the French use to describe real-life events that seem so fantastical, they appear more far-fetched than the most surrealist of fictions. In English, the equivalent expression might be, you can't make this stuff up. But if you look at the Diab affair, they did make it up. They, whoever they are or were, made up the entire yarn with multiple strands of anti-Arab prejudice, and every bit of the narrative is as fantastical as it is far-fetched. In collaboration with foreign agents, French authorities wove a knotted fabric of fictions, lies, and unsworn statements, likely extorted through torture, in order to frame Hassan Diab, to scapegoat him, and thus bring closure to the mystery case of the 1980 Copernic attack, now more than 40 years old. In casting him as a scapegoat, as a shadowy stand-in for the real culprit, French authorities sought to appear successful in catching the bomber. Appear is the operative word here, for it signals an illusion that was manufactured to advance France's counter-terrorist cause and to subdue the victims' lobby with ceaseless calls for retribution. But if the Diab scapegoat surfaced as an expedient mechanism of psychological and political displacement, he had first to be fabricated, afforded a true-to-life character that, to some, at least, he would resemble the real bomber. To be clear, the Diab scapegoat is not a real human being. He is an imaginary persona, a structure of thinking, and those who created this mysterious figure were practicing a politics of distraction, intended to catch public opinion in a web of deceit. Indeed, the entire story that was spun between 1980 and 1999, it took 19 years, and that formed the basis of France's wrongful 2023 verdict was a red herring writ large. The result was a low-grade detective story that is as incoherent and shape-shifting as it is fallacious. In its earliest iteration, 2008 more or less, the story they hatched claimed that Diab traveled to France by train via Spain in order to carry out an attack on Paris's Copernic synagogue. But after 2018, once Diab's alibi came to light, demonstrating that at the time of the bombing he was in Beirut studying for exams, the story had to be adjusted. In that new version of the story, in 2021, Diab was said to have traveled to Paris by plane. He then, it was argued, returned speedily to Beirut just in time to sit the exam. There is no evidence for either of these James Bond-like scenarios. Still, the prosecution's 2023 version circles back to the incoherent first rendition in which Diab is said to have traveled to Paris by train via Spain. But as the French investigative magistrate Jean-Marc Herbeau stated when questioned at the 23 trial, you can't have it both ways. Either Diab went by train or by plane, but not both. A close look at the narrative and its various incarnations reveals a plethora of contradictions, distortions, and unsolved questions. Indeed, the scrupulous work of two French investigative magistrates has illuminated these flagrant discrepancies, underscoring the speciousness of France's anti-Diab tale. Thanks to these two magistrates, Jean-Marc Herbeau and Richard Folzer, Diab's innocence was irrefutably demonstrated in 2018. On January 12th of that year, Jean-Marc Herbeau ordered Diab's release, and with that move, he rendered void the accusatory fiction spread against Diab by French counter-terrorist authorities. If the story that forms the basis of France's verdict is inconsistent in its substance, it is nonetheless consistent in its pattern of occlusions, in its denial of the indisputable evidentiary material. Diab's fingerprints were taken, as he just said, 10 times between 2008 and 2015, and they never matched those of the alleged bomber. And precisely because of this powerful exculpatory evidence, prosecutors went to extraordinary lengths to fabricate inculpatory material in order to bury the inconvenient truth of Diab's innocence. All those actors who sought Diab's prosecution knowingly suppressed, obscured, denied, or stamped out exculpatory evidence. There are 4 major instances in which this burial of evidence occurred, and on which I rest my case. 1, when France presented its record of the case to Canada in 2008. 2, when Canadian Crown attorneys abetted the extradition of Diab to France between 2008 and 2011. 3, when France's appeals court in 2021 reversed the 2018 release order that freed Diab from France's maximum security prison. And 4, when the Cour d'Assize tried Diab in absentia in April of 2023. I call each of these instances conjunctures, and I start with conjuncture 1. On November the 13th, 2008, Diab was arrested. The RCMP took his fingerprints. The latter were sent to France for comparison with the prints of the alleged bomber. On November the 19th, France's investigative magistrate, Marc Trévédic, received a report indicating that Diab's prints did not match those of the bomber. Trévédic did not share this fingerprint comparison evidence with his Canadian counterpart. He mulled over this discomforting news for a few days and decided to omit this fingerprint evidence in the certified record of the case that he submitted to Canada on December the 11th, 2008. Citing a 1980 and thus outdated French police document, which stated that there were no exploitable fingerprints on the hotel card that the bomber had signed, Trévédic dissembled. He used an anachronistic document to conceal his omission of key exculpatory evidence. But as CBC David Cochrane has written, court documents show that France, notably Trévédic's predecessor, a guy named Bruguière, was able to find a usable fingerprint on the hotel card in May of 2007, 19 months before the extradition request was made. Having falsified the certified record of the case in December of 2008, Trevedic, it would seem, had committed perjury on 2 counts. 1, he omitted the results of fingerprint analysis that excluded Diab, and 2, he denied that there were any usable fingerprints. With this deceitful maneuver, he was knowingly pursuing the wrong man, and everything that he submitted in the record of the case to Canada could only have been a tissue of falsehoods. Trevedic's double lie to Canada was only disclosed in 2018 by 2 honorable French investigative magistrates, Jean-Marc Herbeau and Richard Folzer. But France never corrected its false statement and thus misled the Canadian Superior Court of Justice, the Court of Appeal for Ontario, and the Supreme Court of Canada. This first suppression of exculpatory evidence is to be attributed to France, the second to Canada. I turn to the extradition process now to make this plain. We're now at conjuncture 2. Legal scholars such as Rob Curry and Gary Botting have established that Canada's defective extradition law overrides Canada's Charter of Rights and Freedoms. For one, it presumes the requesting state to be reliable. In this, it allows false evidence to be taken at face value as justification to extradite the person sought. The Diab case illustrates this well. False evidence from France was used to send Diab to purgatory in a maximum security prison. He languished there for more than 3 years without charge. But it was not only the law that facilitated this unjust extradition, it was also the agents of the law who proactively sought this expulsion. Canadian officials in the Department of Justice actively propped up the French extradition case, delaying court procedures and withholding vital information. Thus, in November of 2009, they requested a comparative analysis of fingerprints. In early 2010, the RCMP produced the analysis. The fingerprints did not match. The Crown attorneys would have known this throughout the extradition hearing, yet they never shared the information with the defense or showed it to the Canadian judge who made the extradition order. Meanwhile, these Crown attorneys regularly exchanged memos with their French counterparts, pushing for and obtaining court delays until the French authorities could find a smoking gun, one that would guarantee Diab's extradition. What was this smoking gun? Flimsy handwriting evidence discredited fully by 5 international experts and later by French experts themselves. Still, this same repudiated handwriting evidence served as a red herring to distract from the hard scientific fingerprint proof of Diab's innocence, proof that France and Canada sought to conceal at all costs. For a decade, France sequestered possession of fingerprint evidence that would have refuted allegations against Diab. And for 8 years, Canadian government officials also knew that Diab's fingerprints did not match those of the suspected bomber. They withheld this fact from the court, acting underhandedly to abet a French extradition request that was tainted from the outset. Conjuncture 3. In 2021, the French Court of Appeal also attempted to occlude Diab's exculpatory evidence, and they did so with a preposterous argument dubbed the careful bomber theory. With this fanciful claim, they speculated that the bomber took extra care not to leave any trace of fingerprints on the hotel registration card that he signed. Such sophistry recalls Trevedic's mendacious claim that there were no usable fingerprints to exploit, even as comparative fingerprint analyses took place at least 10 times between 2008 and 2015. Conjuncture 4, the trial. During the 2023 trial, a version of this careful bomber theory took on an even more risible form when an ex-police officer unrelated to the Diab case testified that in the 1980s there was a police policy that forbade the suspect from touching the paper on which he signed his name. I think Don mentioned that one. With this fantastical tale, the court categorically averted all mention of Diab's exculpatory evidence. In the same thrust, it turned the public's attention to a doctored-up facsimile of a lost passport, and called this theatrical prop the smoking gun. The 2023 trial of Hassan Diab, held in a court of no record, was a sham, a display of scandalous deceit. Documented fingerprint analysis, which had excluded Diab from the crime of Copernic, was clearly the elephant in the living room, the all too obvious element that prosecutors in 4 major instances sought to quash. And ironically, that suppression of exculpatory evidence occurred most blatantly in a judicial context, where the law purports to serve justice. But a law is a tool, not the actualization of justice. And those who wield that tool do so with political intent. In the Diab case, magistrates, crown attorneys, and judges played fast and loose with the law. It is imperative, then, that we do our utmost to hold them accountable. Indeed, the exposure of their crimes is central to the liberation of our long-suffering but most admirable fellow Canadian, Hassan Diab. The mental torment to which he and his family have been subjected for more than 15, now more than 16 years, is beyond egregious. It must come now to an end with our government's publicly stated response to France. No second extradition for Dr. Diab. Thank you.
All right. Thank you, Michelle. And a big bravo to all our speakers.